Everybody have a seat. Let's go on record in the BRC. Got to state for the names on the record.
Taylor May on behalf of the Office of the State Attorney.
Tyler Brands on behalf of the Office of Public Defender.
Let's get to our third today motions this morning. First one I have is Atwell 2020 CF 1584 AO.
Is that 15284?
Sorry, 15284 AO.
Notice and on filing.
And granted. 15. I have Cabreja 2021 CF 5416 AO.
Filed yesterday.
Denied. I have Porter 2021 CF 2021 CF 5550 AO.
Notice and on filing.
Granted. I have Franklin 2021 CF 5513 AO.
Notice and on filing.
Granted. I have Watts 2021 CF 5508 AO.
Filed yesterday.
Denied. I have Mullendor 2021 CF 5556 AO.
Notice and on filing.
Granted. I have Abdul 2021 CF 2422 AO.
Filed yesterday.
Denied. I have Henny 2021 CF 5434 AO.
Filed yesterday.
Denied. I have Davis 2021 CF 5581 AO.
Notice and on filing.
Granted. I have Watts 2021 CF 5509 AO.
Notice and on filing.
Granted. I have Smith 2021 CF 5591 AO.
Filed this morning.
Denied. I have Quintana 2021 CF 458 AO.
Notice and on filing.
Granted. I have Cersei's 2021 CF 5161. I'm sorry, 5167 AO.
Filed yesterday.
Denied. I have Prior 2021 CF 4755 AO.
Notice and on filing.
Granted. There's no witnesses today? I understand, I just don't see anybody in the gallery, so before we get started here. That's why I call down to find out.
Good morning, Your Honor. This is Rafael Barrera, State Certified Court Interpreter, previously sworn.
Come on, Mr. Barrett, give him one moment.
Yes, Your Honor.
Mr. Barrett, this is Judge Bain calling from the BRC. I have a few defendants I need your help with this morning. You see if we can make a connection to the headsets.
Yes, Your Honor. Allow me just a moment to confirm.
Sí.
Good
Your Honor,
morning.
the interpreter can confirm the defendant is able to hear through the headsets.
Good morning, sir. Can you tell me your name?
Eliud Caraballo Cruz.
Helio Caraballo Cruz.
Mr. Caraballo Cruz, you're here this morning in 2021 CF 7047AO on charge of tampering with a witness, hinder communication, battery, domestic violence, and assault domestic violence. I reviewed the charging affidavit in this case. They find probable cause for your arrest. I'm going to set your bond at count one, amount of $1,000. Count two, 500. Count three, 500. Conditionally, your bond that you have no contact with the victim in this case. You need to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any items you may have at the shared residence. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I want to appoint the public defender to represent you in this case, sir. Have a great day.
Sure. Sorry.
All right. Well, sir, you will have the right to remain silent, not talk about the facts of your case.
I just want to know if the bill is 10% or just straight 1,500.
That's, you need to work that out with the bondsman. You said you can post your own bond, or you can have a bondsman. So up to you. Yes, ma'am. Well, State, for our third day motions for prayer, we had another case, 2021 CF 4758AO.
Said 4758.
Yes, ma'am. That's it for the interpreter. Thank you, Mr. Interpreter.
Thank you, Your Honor. Have a good morning.
You too.
21 CF 4758, Miss Prior,
Yes.
is also a notice of non-filing.
All right, I'll grant that one. Yes. Good morning, sir. Can you tell me your name?
Angel Santos Rodriguez.
Mr. Santos Rodriguez, you're here in three matters. The first one is 2021, CF 6951AO. You've been charged with burglary of a dwelling, criminal mischief of $1,000 or more, possession of heroin, possession of cocaine, and resisting officer without violence. You have problems hearing me?
Okay.
In that case, sir, I'm going to set your bonding, and as your burglary of a dwelling, amount of $15,000, $1,000 as your criminal mischief, $100 as your possession of cocaine, $100 as your possession of heroin, and $100 as your resisting officer without violence. Condition of that bond not return to the scene of the location. You have no contact with any victims or witnesses from that case. You're also not allowed to possess any drugs, alcohol without a valid prescription. You're also arrested on warrants in 2020 CF 244AO, a charge of grand theft, violation of the Pawnbrokers Act, and dealing in stolen property. Want to stay your bonds amount of $3,000, $2,000, and $2,000. Condition those bonds, no return to the scene of the location, have no contact with any victims or witnesses from that case. You may not engage in any secondhand pawn transactions while you're out on release in that case. You're also arrested in case 2020 CF 8767AO for a charge of aggravated battery on a pregnant person. Going to set your bond in that case amount of $25,000. Condition of your bond that you have no contact with the victim in that case, not return to the scene of the location of that incident. That you not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. I'm going to appoint the public defender to represent you in all your cases. You have a great day, sir.
I called the police about when the baby. They took my wallet.
He's asking, is there a way to get his cell phone back so he can call his mom?
I don't need my
What?
cell phone, just my number.
Just the number for his mother to call her.
Take my phone.
I don't know about that. You got to work with your attorney. If you need some kind of return of property or turn over the property to somebody else. I had a reset with Ms. Dickerson next.
You said it's who?
Tara Dickerson, I had a IA hold reset. She had another case, a second case she's out on bond on. Because that's what a note I have.
I don't have it.
All right. I have her inmate number, I'm not sure. It says here 21-014-015. I saw her yesterday for a petty theft 2 prior case and possession of methamphetamine. She's out on bond. I'm trying to think. I took action on some case, but I don't know. Did she have another case or
I
something?
guess it's another fad they must have caught. So
Okay.
you revoked the other one.
Yeah, I broke the other one. I think I set her bond at $10,000 or something, and then,
Do you want to take action on this one?
I can. I saw Ms. Dickerson yesterday in case 2021 CF 6981AO. She was arrested for several charges, I think petty theft 2 prior, I think resisting merchandise recovery, possession of methamphetamine, and I think
Battery.
battery, I believe, with the
resisting
other
without.
charge. She had another case I revoked her bond on. I set a bond at $10,000. I'm gonna revoke this bond in case 2020 CF 123AO. Gonna set her new bond at none in that case. She's already represented by the public defender's office in that case. Good morning, sir. Can you tell me your name?
Morning. Kendrick Jackson.
Mr. Jackson, you are here in case 2021 CF 7015AO on charge of battery, 1 prior battery, domestic violence. I reviewed the affidavit in that case. I found probable cause for battery, but I don't see anything. Is this history complete? Nor do I see anything in the charging affidavit that alleged that he has been convicted of got a withhold and/or adjudication in a prior battery case. All right, so what we did to get the state of Florida a chance to look at that. You also arrested in 2021 MM 364AW on charge of resisting officer without violence. I did review that charge and affidavit, did find probable cause for your arrest as to that charge. As to that charge, I'm going to set your bond in the amount of $250. Unless the state, you're going to rule and resolve that case.
Not at this time, Your Honor, given the battery. All I have is a 20 misdemeanor non-arrest battery, declined to prosecute 17, bat DV, declined to prosecute 16, bat DV, declined to prosecute 14, declined to prosecute 14, bat DV, declined to prosecute 2011, bat DV, declined to prosecute.
Are these all the same victim or different victims?
2011 was Miss Orr. 2014 was Miss Orr. 2014 again was Miss Orr. 2016 is Miss Orr. 2017 Miss Orr. 2020 is again Miss Orr.
All right, sir, as 2021 CF 7015 AO, I'll charge, if I did find probable cause for battery, domestic violence. As to that, of course, going to set your bond amount of $1,000. It's going to come with pretrial release in this case. Condition of that pretrial release that you had no contact with the victim in this case. You need to maintain a separate residence from this victim.
Yes, sir. I am. As soon as I get out of here.
I give you a one-time return if you have a shared residence with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. We want to appoint a public defender to represent you in both your cases. You have a great day, sir. Yes, ma'am.
You too.
Him on pre-trial release for the other case as well.
Might as well.
Yeah.
Actually, I won't do 250 bond. I'll just put you straight PTR on the resisting case. Straight PTR, same conditions as the other case. All right. Good morning, sir. Can you tell me your name?
John Anthony Alexander.
Sir, Mr. Alexander, you're here in case 2021 MM 363 AW on charge of battery domestic violence. Can you tell me your name, ma'am?
Renee Hall.
Ms. Hall, you are here in case 2021 MM 362 AW on a charge of battery domestic violence.
Yes.
I did review both of your charging affidavits, did find probable cause for your arrest as to the charge. Mr. Alexander, can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, put your hand down. Can you tell me how you know Ms. Hall? All right. And do you want to have contact with her while this case is pending?
Repeat it. You said, do I want to have contact?
Yes, sir.
Yes, sir.
Are you afraid of her?
No, sir.
Has there been any prior instances of domestic violence between you all in the past?
No, sir.
Did drugs or alcohol play a role in this incident?
No, sir.
Ms. Hall, can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
You put your hand down. Can you tell me how you know Mr. Alexander?
He's my boyfriend.
And do you want to have contact with him while this case is pending?
Yes.
Has there been any prior instances of domestic violence between you all in the past?
No.
Did drugs or alcohol play a role in this incident?
No, sir.
All right.
Your Honor, they both do qualify for PTR, but
Yeah, yeah.
Ms. Hall does have a very,
Yeah, but they're both charged with dangerous crimes, so you got to deal with that part of the statute as well. State, can you tell me about Mr. Alexander's prior domestic violence arrest here? Did I see?
Yes.
Ms. Hall, were you aware of Mr. Alexander's prior domestic violence history?
No.
I have a 2019 non-arrest BAT DV against a different victim, Ms. Smith. We declined to prosecute due to mutual combat. I have a 2015 non-arrest stalking DV. That one is Miss Alexander. I believe it was his ex-wife. It was declined to prosecute. A 2015 injunction, violation of DV injunction and being in a prohibited place within 500 feet. That one, he pled no contest. Victim being Miss Alexander, I believe his ex-wife. Then I have a 2014 felony ag assault with a deadly weapon DV, criminal mischief. Victim being Miss Alexander, his ex-wife. She was unwilling to prosecute that case. And then a 2012 misdemeanor assault DV. Victim being Miss Alexander. The victim was unwilling to prosecute.
Mr. Alexander, we're going to set your bond in your case amount of $1,500. Condition of your bond, be pretrial release supervision. You had no contact with Ms. Hall. Condition of, must maintain a separate residence from her. You all live together?
He lives with his mom, but he spends the night at my house a lot. He has things there, though.
I'll give you a one-time return with law enforcement to retrieve any of those personal items you have at Ms. Hall's residence. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I want to appoint the public defender to represent you in this case. Ms. Hall, I'm going to set your bond in your case amount of $250. It's going to come with pretrial release supervision, that you have no contact with Mr. Alexander. Conditions of, you must maintain a separate residence from him. I also like to make a notation that she is the person that lives at the house, and that's her house she's returning to. I'm not going to say, give her a one-time return because she lives there. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You understand that, ma'am?
Yes.
Want to appoint a public defender to represent you in your case as well. One of you is going to get the public defender. Somebody else is going to get what they call regional conflict counsel, which is an attorney that's still paid by the state of Florida, but they have your interests at heart, not Mr. Alexander's interests. You understand that? All right, everybody have a great day. Good morning, ma'am. Can you tell me your name? Ms. Bello, you're here in case 2021 MM4082AO on charge of battery domestic violence. I did review the charging affidavit in your case. I did find probable cause for your arrest. I'm going to set your bond in this case amount of $250. It's going to come with pretrial release supervision. You're to have no contact with the victim in this case. You are to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location.
Thank you.
You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I'm going to appoint the public defender to represent you in this case. You have a great day, ma'am. Good morning, sir. Can you tell me your name?
Eric Andrew Felperin.
How do you say your last name?
Felperin.
Felperin. Mr. Felperin, you are here in case 2021 MM4087AO on charge of battery domestic violence. I did review the charging affidavit in your case. I did find probable cause for your arrest. I'm going to set your bond in this case amount of $500. It's going to be subject to pretrial release supervision. You have no contact with the victim in this case. You are to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you may have at that shared location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You also may not possess any drugs or alcohol without a valid prescription. You'll be subject to random drug and alcohol testing at your expense. I'm going to appoint the public defender, says you don't qualify. Says you make $1,000 per week.
No, I thought they meant bi-weekly, sir. That was my mistake.
So 2,000 a month. All right, sir, based on that new information, I'm going to appoint a public defender to represent you. You have a great day, sir.
Thank you, sir.
Good morning, sir. Can you tell me your name?
Just a moment, Your Honor. I think Mr. Lorenzen wants to confer, if just a moment. Your Honor, you can announce the case.
Mr. Lorenzen, you're here in case 2021 MM4086AO on charge of battery domestic violence. I reviewed the charging affidavit, did find probable cause for your arrest. I'm going to,
Your Honor, I don't believe he was interviewed by pretrial services. If interviewed, would he otherwise qualify for PTR?
Interviewed.
I'm sorry?
it looks like
He was interviewed, he don't qualify.
yeah, it looks like he was interviewed and so he couldn't make contact with his emergency services, like any emergency contact for him. Was that the only reason?
I'm guessing also in regards to his criminal history, he has a lot of violation of probation.
All right.
My only issue, Your Honor, is he's informed me that due to his income, he wouldn't afford a monetary bond at this time, so he was requesting if he could qualify for PTR, but if not, I would still suggest a lower monetary bond due to his income status.
Your Honor, respectfully, I respect that argument. However, this is bordering on a felony battery by strangulation. It is alleged in the affidavit that he grabbed her by the neck and started squeezing to the point that it was hard for her to breathe. However, she advised she never lost consciousness. And the officer noted red marks along the side of her neck and appear to be micro blood vessel ruptures consistent with human skin and muscle being squeezed.
Right. All right, Mr. Lorenzen, one, you don't qualify for non-monetary release in this case because you're being charged with what is legislature has determined to be a dangerous crime. Two, based on looking at your failure to appear and violations of probations on your record, I do agree with pretrial release that you probably aren't a good candidate for their services. I am going to set your bond in your case in the amount of $2,000, conditioning your bond that you have no contact with the victim in this case. You need to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be returned over to law enforcement within 24 hours of your release. Do you have any questions about the no contact order, sir?
I just got a question about my bond. How am I gonna pay it if my job? I gotta pick up, it's a cash check, and I'm the only one that could pick it up. There's no way I could pay for this.
Also, Your Honor, is the higher bond due to the criminal history or due to what the state said about other possible charges? Because I think the
it's
current
more-
charge is
it's
only
two
battery.
things. Level of violence this wasn't just a shoving match, like, some of the cases that we see all this morning already. This was borderline on a violent attack on somebody that I consider to be pretty relatively violent, as well as his violation of probation history and failure to appear history. It concerns fulfill that bond amount fulfills all the statutory requirements that I have to consider. And whether he's gonna return to court, stay out of trouble, keep the public safe.
I will say that's in the past. You're looking at a past record.
Yeah. If I had a reason, if I had the ability to predict the future, my man, I would not be sitting here. So the only thing I can do is estimate on previous behavior. Good morning, ma'am. Can you tell me your name?
Catherine Marlowe.
Ms. Marlowe, you are here in case 2021 MM4064AO on charge of battery domestic violence. I did review the charging affidavit in your case, did find probable cause for your arrest. Going to set your bond in your case amount $250. It's going to come with pretrial release supervision. As you have no contact with the victim in this case, you need to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you may have at a shared residence. You may not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. I want to appoint the public defender to represent you in this case, ma'am. You have a great day.
Thank you. Thank you.
This is Mr. Pryor in case 2021 MM4081AO. Would appoint the public defender to represent him.
We'll waive the appearance, Your Honor.
State, were these prior DV cases against his own children, or they are involving some kind of a spouse or?
2007 CF false imprisonment, bat DV, was against Tasha Pryor, so the spouse. A 2008 felony, bat DV, one Pryor, was against Miss Pryor, the spouse. The 1998 bat DV was against Miss Pryor before she was his wife.
All right, in this case, I want to set his bond in the amount of $2,500, condition of his bond, that he have no contact with the victim in this case. He's to maintain a separate residence from the victim. I'll give him a one-time return with law enforcement to retrieve any personal items he has at the location. He may not possess any weapons or firearms. Any weapons or firearms he has need to be returned to law enforcement within 24 hours of his release. If he is seeing a medical doctor, he needs to be making all his mental health appointments as a condition of his bond, take all his mental health medications in the dosage that is prescribed to him by a medical licensed professional. He's also not allowed to possess any drugs or alcohol without a valid prescription.
Your Honor, I'm sorry, was that 2,500?
Yes, ma'am. Good morning, sir. Can you tell me your name?
Eves Regis.
Mr. Regis, you are here in case 2021 MM4089AO on charge of battery domestic violence. Did review the charging affidavit in your case, did find probable cause for your arrest. Going to set your bond in your case amount of $1,500. Condition of your bond that you had no contact with the victim in this case. You need to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. Do you have any questions about a no-contact order? I'm going to appoint the public defender to represent you. You have a great day, sir. Actually, hold on, wait. I got a note. It says you make $700 a week.
Yeah, I was hoping that I was gonna get an R&R or something so I could go to work.
Now, you can't, you're charged with dangerous crime, can't be RR'd, but you make $700 a week.
Right.
All right, so I don't think you're gonna qualify for the services of the public defender at this time. You're gonna hire your own attorney. All right, have a great day, sir. Good morning, sir. Can you tell me your name?
Cameron Rice Peachy.
So you're here this morning in case 2021 MM 4064AL on charge of battery dating violence. Did review the charging affidavit, did find probable cause for your arrest. Going to set your bond in this case an amount of $500. Condition of your bond is that you have you're subject to pretrial release supervision and you have no contact with the victim in this case. You need to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. You're also not allowed to possess any drugs or alcohol without a valid prescription. Be subject to random drug and alcohol testing at your expense. We're going to appoint the public defender to represent you in this case. You have a great day, sir. All right. Good morning, sir. Can you tell me your name?
Morning, sir. Stephen Robinson.
Mr. Robinson, you are here this morning in case 2021 MM 4061AO on charge of battery domestic violence. Did review the charging affidavit in your case. Did find probable cause for your arrest. Going to set your bond in the amount of $500. It's going to come with pretrial release supervision. You'd have no contact with the victim in this case. You need to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. I want to appoint a public defender to represent you. One second, Dexter. Mr. Brands, can you find out the child that was mentioned in this case? Is that his child? And how does he plan to provide support for that child while he's being separated right now?
Yes, Your Honor, the child is his, but it'll be safe at home with the mother. The only issue I have, Your Honor, is the family court issue of any kind of order that involves paying into a shared bank account for living expenses or anything like that. I think that's within the purview of the family court as opposed to initial appearance court. I don't believe an ordering him to pay into something. I think that should be dealt with evidentiary hearings in front of family court.
I agree to evidentiary hearing. My order is going to be kind of more general. Is that Mr. Robinson, my order is you continue to provide support for your child because that's what the law says you have to.
I'm just worried that because of those orders that he might come into violation of the no contact order, because if he's trying to arrange payment for child services and living expenses and things like that, it might grow dangerously close or move dangerously close to violating the no contact order. That's why.
Right, that's why I'm making the exception that he continue to provide. You have a shared bank account where you guys pay bills out of, You gotta continue to put money in that account so the bills are paid, so your child has a place to live and fast food, all those kind of things like that, that the law requires that he does, period, as a parent.
But if the alleged victim tries to contact him asking about those living expenses, is he able to contact her back?
Nope.
That's where my issue is that if he's trying to abide by one order, he may end up violating another order.
I understand that.
I think it would be better set in front of family court with, at least with the expense order, with the monetary order of
Right.
providing living expenses, so that he can abide by the no contact order now. And then
Because
front
in
of
family court, it's
have-
still the same thing. Family court is still, like, there's still situations where such a parent has exclusive, jurisdiction or custody of the child, and and the other parent is still required to pay their child support.
I understand,
And
but
every
then-
month, it
but
gets
then the
paid into their bank account. It's not a form of contact. It's whatever, like, so I'm saying, so whatever it is that's been before in the past, it continue to go on until you can get in front of a circuit court judge, or a county court judge, and they're able to modify that to make it make more sense. If there's another changes, child's sick, different things to come up, this you need to approach the court to make sure that those things are taken care of. What I don't like to happen, what kind of the court finds discouraging, is that people get involved in domestic violence cases, a child's involved, and they share a child, and they start to withdraw support for that child. Child has nothing to do with you and your other spouse and why y'all can't work out your problems, or that person.
I understand. I
That's
just-
an
I
unreasonable,
think
that's an
there's
unreasonable
conflicting orders.
resolution or solution or outcome that I don't think the court should accept.
I understand, I just think it's conflicting orders. I'd still object, Your Honor.
Yeah. So my intent is that whatever, if you pay the rent, rent's paid. All right. One more thing, Mr. Robinson, it says you make $1,000 a month, or a week, is that true? All right. You're not gonna qualify for the services of the public defender, so I'm not gonna appoint them to represent you in this case. You're gonna have to hire your own attorney. But my orders can be modified by the division judge, but between that time, I wanna make sure everything stays status quo, at least in that child's life.
Can I speak?
Don't talk about the facts of your case, but if you have something else you need to talk to me about.
You said that I don't qualify,
Yes, sir.
but my bills are $3,200 a month.
Wait, Madam Clerk told me I need to calculate this is by your gross income. I understand, am I wrong? Am I supposed to use this gross income or this net income to deal with whether he qualifies or not? I'll appoint the public defender to represent you. I think it's somewhere in the middle. I think somebody's gross income, they have bills that, exceed that income or sometimes, come close to that. Obviously, technically, you're indigent because you're paying out more than what you make. So, you're kind of running on that line. Where you have a surplus of only a couple of $100 a month. All right, have a great day, sir. Good morning, sir. Can you tell me your name?
Michael Shaw.
Mr. Shaw, you're here in case 2021 MM4088AO on charge of battery domestic violence. Did review the charging affidavit in this case, did find probable cause for your arrest. I'm going to set your bond in this case an amount of $1,500. Actually, no, sorry, $2,000. Additionally, your bond that you have no contact with the victim in this case, that you do not maintain, you must maintain a separate residence from this victim, I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. You may not possess any drugs or alcohol without a valid prescription. You'll be subject to random drug and alcohol testing at your expense. I want to appoint the public defender to represent you. Go ahead, Mr. Branson.
Just a moment, Your Honor. Did pretrial services interview Mr. Shaw? By
He
chance?
was interviewed.
He was interviewed and he didn't, what was the reason for not qualifying?
Well, he has a lengthy history, and he's also a multi-state offender. He has an active injunction on a different victim.
Good morning, sir. Can you tell me your name? Mr. Townsend, you're here in case 2021 MM 240AA on charge of battery domestic violence. They reviewed the charging affidavit in your case. Did find probable cause for your arrest. All right, sir, I'm going to set your bond in this case in amount of $1,000, conditional on your bond that you have no contact with the victim in this case. You need to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at the location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. I want to appoint the public defender to represent you in this case, sir. You have a great day, sir. Good morning, ma'am. Can you tell me your name? Ms. Walker, you're here in case 2021 MM 4070AO on charge of battery dating violence. Did review the charging affidavit in this case, did find probable cause for your arrest. Good morning, sir. Can you tell me your name and spell your last name?
My name is Justin Figueroa, last name spelled Figueroa.
And can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Put your hand down. Can you tell me how you know Ms. Walker?
Miss Walker is my girlfriend. We've been together for 4 years.
And do you want to have contact with her while this case is pending?
Yes, I do, sir.
Are you afraid of her?
No, sir. Everything was a misunderstanding.
This looks a little more than a misunderstanding. I don't know, what's your definition of misunderstanding?
She just got a little upset, and then when you call the police, you got to call the police when you're in danger, and she wasn't in danger.
All right.
But she's
Has there
never,
been any types of, like, prior incidents of domestic violence in the past?
no, sir, she's never even been arrested until yesterday.
Well, that's not my question. My question is, has there been any prior instances of domestic violence in the past?
No, sir.
Something like this were to happen in the future, do you feel comfortable contacting law enforcement?
Yes, sir.
State, you have any questions for the witness?
No, Your Honor.
No
Ms. Rice.
questions, Your Honor.
Ms. Walker, I'm going to set your bond in this case amount $250. It's going to come with pretrial release supervision. You had no hostile contact with Mr. Figueroa, do you understand? No hostile contact means this. This misunderstanding is what Mr. Figueroa calls it. It's going to get you arrested. Because I'm going to order that you obviously cannot be physical with him. You cannot be violent. There can't be no threatening language. You understand that? Or abusive language. Because if Mr. Figueroa calls the police, or somebody sees or hears you all arguing and they call the police, you're going to be arrested. You're going to spend the remaining of your time here with me at the Orange County Jail. Do you understand that? You may not possess any weapons or firearms. Any weapons or firearms, you may not. So you may not possess any weapons or firearms. I'll give you 24 hours to turn any weapons or firearms over to law enforcement. I'm going to appoint the public defender to represent you. You have a great day, ma'am. Can you tell me your name, sir?
Michael White.
Good morning, Mr. White. You are here in case 2021 MM 4083AO on charge of battery dating violence. I did review the charging affidavit in this case, did find probable cause for your arrest. Say, can you tell me about this prior domestic violence case?
Yes, Your Honor. I have a 2019 felony grand theft motor vehicle, BAT DV. The victim was Ms. Ibrahim. I have a juvenile battery, a 2012 non-arrest misdemeanor, BAT DV, victim in that case being Ms. Smith.
All right, Mr. White, going to set your bond in this case amount of $1,500. Condition of your bond that you have no contact with the victim in this case. You must maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I want to appoint the public defender to represent you in this case. Do you have any questions about the no contact order?
I just, when I get released, I just need the police to be over there so I can go get my belongings, and I'm going to West Virginia.
All right. Well, you need to make sure you come back and don't violate my orders in West Virginia.
I'm coming back.
I'm just telling you, because if you know, we extradite from everywhere, so.
You know what, y'all do it for anything, so
Yeah.
y'all gonna show.
Exactly. Have a great day, sir.
Misdemeanor, y'all gonna do it for felony, so.
Exactly. All right, have a great day, sir. Well, somebody knows. Good morning, sir. Can you tell me your name?
Randolph Wright.
Mr. Wright, you are here in case 2021 MM 4076AO on charge of battery domestic violence. I did review the charging affidavit in your case, did find probable cause for your arrest. I'm going to set your bond in this case in the amount of $250. It's going to come with pretrial release supervision that you have no contact with the victim in this case. You need to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you may have at a shared residence. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. Do you have any questions about the no contact order?
No, sir, I think you made it clear. I do have some personal belongings there still.
Yeah.
You know, and I was in the process of moving out when the incident occurred. So I'd like to retrieve.
Yeah, that's why I'll give you the one, you gotta go with law enforcement. Don't go there by yourself.
No.
Because you're gonna get arrested. So go with law enforcement, call them, follow the procedure, do what they tell you to do. That way you don't have any problems. It says, that you make $800 a week.
Yes, that's net.
All right. Don't think you're gonna qualify for the services of the public defender based on that. So you're gonna have to hire your own attorney. All right. You may have to file another affidavit later on, find a different determination.
Your Honor, with the expenses that I have right now, I just can't afford it. I'm moving into a new apartment, and with all my other expenses, I honestly just can't afford that right now. That's why I requested one in the first instance.
All right, well, you got a way out today because the Florida Supreme Court hasn't changed my order to appointing the public defender, so I'm going to appoint the public defender to represent you in this case. Make sure you call them and keep in contact with your attorney. Have a great day, sir. Good morning, sir. Can you tell me your name?
Miguel Obamaka.
Sir, you're here in case 2020 CT 14708W on a violation of conditional release. The judge signed your warrant. In this case, that's your bond amount of $5,000. Condition of, I want to add a condition to your warrant, and that bond is that you not possess or consume any drugs or alcohol while you're out on release. You be subject to random drug and alcohol testing. All right. Yep. And Mr. You represented by Mr. Ali. Have a great day, sir.
You gonna take any action?
I can't, this is the exact opposite problem. He was arrested on the other case where the judge probably should have took action on the case I just announced. So I can't take any action on your other case. So have a great day, sir. Good morning, ma'am. Can you tell me your name?
Sarah Harris.
Ms. Harris, you are here in, did you get a case number finally? I didn't have a case number for this case, so I was wondering if we got one yet. From Ms. Harris. I don't have a case number for this case on my paperwork, so I was wondering if you had a, was they, were they, did they? Okay. All right. All right, ma'am, you were arrested for the charges of driving under the influence of property damage or personal injury and refusal to submit to a DUI test. Your bond account in the DUI property damage is $2,000, and the refusal is $1,000. Condition of both your bonds is you're not allowed to possess or consume any drugs or alcohol while you're out on release in this case. You may not, you'll be subject to random drug and alcohol testing at your expense. Do you understand that? Yes, ma'am.
I'm so sorry, Your Honor. The reason why her bonds are so high because they said they doubled it because she resides out of state, but she gave us a Hollywood, Florida address.
Yeah.
So I just need to make sure
All right.
she's staying in state. If you
So-
got drug testing.
Well, the other issues that was just.
She can qualify
Oh,
for
one second,
PCR.
1 second. Well, my issue is that she's out on release or something in a Brevard County case for the
Oh, I'm
same
sorry.
exact offense. So I thought those bonds were reasonable based on the information I had on my sheet.
Okay.
But still no drugs, no alcohol. You'll be subject to random drug and alcohol testing while you're out on release. Is she a public defender app? All right, ma'am. 650. Says you make $650 a week? How much money do you make a week?
About that much?
And your total bills are $1,500?
Yes,
Is that per month? Every other, like,
per month.
all right, I'm going to appoint the public defender to represent you in this case. You have a great day, ma'am.
I'm unsure as of right now.
Of what?
Like today or in general? Like going forward or a public defender today or like for like,
You fill out an application, I appointed an attorney to represent you. You can
Yeah.
always hire your own attorney if you have the money to do that.
okay,
But it's up, well, right now, so you have an attorney during the process, unless you don't want one, you want to represent yourself, there's always a choice you have.
okay. No, it's fine for right now.
All right, have a good day, ma'am.
Okay.
All right. Lee?
Funded.
All right, I had Rogers.
Medical.
All right, it's 2021 CT 4124AO. Ms. Rogers is represented by the Public Defender's Office. What do you want to do as to her arraignment?
We'll waive the appearance, Your Honor, and enter a plea of not guilty.
Let's set her for Division 81.
Division 81 pretrial conference, July 16, 9 a.m., courtroom 4E.
At Gaither, 2000,
Medical.
all right, 2021 MM 307AW, supposed to be on charge of exposure of sexual organs for arraignment, represented by the Public Defender's Office.
We'll waive the appearance, Your Honor, and enter a plea of not guilty.
All right, seven for Division 62.
Pretrial conference, July 19, 9 a.m., courtroom 9B.
And good morning, sir. Can you tell me your name?
Brian Torres.
Mr. Torres, you are here for arraignment this morning in case 2021 MM 3767AO on charge of violation of domestic violence injunction. That's a first-degree misdemeanor. It's punishable by 1 year in the county jail and a $1,000 fine, represented by the Public Defender's Office.
We'll enter a plea of not guilty, Your Honor.
All right, sir, we're going to set you for Division 50 for pretrial conference. Nope, we gotta have your dad here.
We're okay, Your Honor.
All right,
Thank you.
have a great day, sir.
Madam Clerk, can we have the date, please? Thank you.
All right. Good morning.
Good morning. This is Paulo Lara, Portuguese interpreter.
Have you been sworn in this morning?
Yes, I have.
All right, I need your help with one defendant. His case number is case 2021 CF 70110. He's standing in my lectern. Can you ask him to tell me his name?
Você poderia dizer o seu nome, por favor?
William Carlos Ávila de Mello.
William Carlos Ávila de Mello.
Sir, you are here in case 2021 2021 CF 7011.
Senhor, você está aqui sobre o caso 2021 CF 007011AO.
Your charges are battery, domestic violence, criminal mischief of $1,000 or more, and aggravated stalking and domestic violence.
A acusação é de violência e a violência doméstica e agressão e, na verdade, o valor seria de $1.000.
The judge signing your warrant has already found probable cause for your arrest.
E o juiz determina que provavelmente há base factual para a sua ordem de prisão.
I want to set your bonds as follows.
Eu gostaria de saber a fiança da seguinte forma.
Count one, $2,500. Count two, $1,000. Count three, $5,000.
The interpreter would like to ask that the count one amount is repeated, Your Honor.
Count one, $2,500.
Então, no caso, vou estabelecer a fiança para você da seguinte forma. Na acusação número 1, $2.500. Na acusação 2, $1.000. Na acusação 3, $5.000.
You have no contact with the victim in this case.
Você não pode manter nenhum contato com a vítima neste caso.
Your Honor, state would also ask for a no contact with the witness.
You have no contact with any. Shall have no any contact with any witnesses.
O meritíssimo, o Estado gostaria também de pedir que não seja mantido contato com nenhuma das testemunhas também. Sim, você não pode manter contato com nenhuma das testemunhas.
You shall have no contact with this victim's family.
E você não pode ter contato também com a família da vítima.
You must maintain a separate residence from this victim.
E você precisa manter uma residência separada da vítima.
Your Honor, state would also request a no return to the mother's address and not to be within 500
I
feet.
think she lives with the mother, so I think
That's
so. It's the no contact order includes no return to the residence. Do you have any-
E também, o Estado gostaria de solicitar também que seja solicitado que ele não retorne à residência, ao local, e mantenha uma distância de 500. The interpreter would like to ask the distance to be repeated.
Say again, Mr. Interpreter.
The interpreter would like to ask that the distance that he needs to maintain is repeated.
It's 500 feet.
500 pés de distância da vítima ou do local.
Did you have any questions about the no contact order, sir?
Você tem alguma pergunta com relação à ordem de não manter contato, senhor?
Não.
Não.
You must not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release.
Você não pode manter e ter em sua posse nenhuma arma ou arma de fogo. E se você tiver qualquer arma, você precisa entregar à polícia dentro de 24 horas após a sua libertação.
I'm going to appoint the public defender to represent you in this case.
E eu vou nomear um advogado da Defensoria Pública para te representar neste caso.
So you asking for anything else?
No.
Mais alguma coisa? Não, meritíssimo.
All right. Have a great day, sir.
Your Honor, he
Yes,
does
ma'am.
have
What?
an immigration detainer.
That's what I was looking at. Sir, it seems you maybe have a detainer from Immigration Customs and Enforcement.
The interpreter would like to ask that to be repeated, Your Honor.
He has a detainer from the Immigration Customs and Enforcement.
Parece que você tem documento de retenção da imigração e da alfândega.
So you may not be able to be released right away. You may have to talk to them first.
Talvez você não possa ser libertado imediatamente, você precisa falar com eles primeiramente.
All right, everybody have a great day.
Tenha um ótimo dia. May the interpreter be excused, Your Honor?
Yes, sir.
Thank you. Have a great day.
on behalf of the Office of State Attorney.
Tyler Brands on behalf of the Office of Public Defender.
Good morning, Your Honor. This is Theodore Leal, Spanish interpreter. The interpreter has been previously sworn, Your Honor.
Thank you, sir. If you could please connect to the headset.
Sí, señor.
Connected, Your Honor.
Sir, please tell me your name.
Raymond Noel Acevedo Rosado.
Noel Acevedo Rosado.
21 CF 7041, you're here charged with possession of synthetic cannabinoids. There is probable cause. I'm going to appoint the Public Defender's Office to represent you. Your bond in this case will be $1,500 with special conditions. You're not allowed to have any contact with the co-defendant. You're not allowed to have any contact with any known drug dealers. You cannot possess or consume a controlled substance without a valid prescription. Do you understand?
Sí, señor.
Yes, ma'am.
You're also not allowed to return to 400 West Washington Street. Do you understand that?
Sí, señor.
Yes, sir.
I show that you were released on your own recognizance in 21 CF 1883 for the same charge. At this time, I'm revoking that bond. No objection to setting a new bond, Your Honor.
Estoy en fianza.
Yeah, if I may, Your
I didn't have a bond.
he has a chance to complete a pretrial diversion program. Use the money for it. And I've also been doing research on the addiction effects of K2. Can be addictive, affects the body, and
I can't hear you, Counselor.
I've been researching the addictive effects of K2. It can result in headaches, anxiety, depression, and irritability unless they get more K2. So I wonder if the addiction has something to do with is back here on the same charge as his out on bond case. That we just a different monetary bond on the out on bond case instead of revoking and setting that none.
Counselor, he was released in May for this charge, and he's been arrested now in June for this charge. What reasonable conditions can this court place on your client with which your client will comply, given the fact that he hasn't in the past, which we know because he's here?
I can't guarantee how addiction is affecting him physiologically. I don't know if he can confirm that he won't attempt to use this drug again, but I can guarantee that addiction can be your body telling you to take something over and over and over again. The addictive effects of certain drugs, and I see that the Drug Institute has said that K2 can be addictive, so I would just
So what you're telling the court is there are no reasonable conditions this court can place on your client with which he'll comply?
holding him here for an addiction issue and not a violent offense against a person, I feel is unfair. I know the higher monetary bond may shock him into realization that he shouldn't be taking this drug anymore or avoid new law violations. I think that would be sufficient.
Does the state have any idea about any reasonable conditions this court can place on this defendant? The state does not, Your Honor. Yeah. That's my concern. A condition of being out on bond is that you not be arrested for a new law violation.
Again,
All right, I'll set this bond at $3,000 with all the same conditions. Good luck, sir.
I'm sorry, Your Honor. Could Your Honor please repeat the case number? Sorry.
#21 CF 7041.
Thank you, Your Honor.
All right, that's it for Spanish cases. Thank you.
You're welcome, Your Honor.
Please tell me your name.
Brian Bookard.
You're here in 21 MM 365, charged with battery. I'm going to appoint the Public Defender's Office to represent you. There is probable cause in this case. Your bond will be $500. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes.
You're not allowed to possess a weapon of any kind, firearm or ammunition. Were you two living in the same residence?
Correct.
All right, you can't do that at this time. I'll order you have to maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim. Do you understand?
Ma'am, I would like the victim then give the officers.
Don't start talking about.
All right, well, I have one question.
Yes, sir.
I'm assuming I'm gonna be in here for over a week if I can't pay my bond, correct?
Well, you have that bond, but I'm also going to revoke your bond and you're out on bond case.
Okay.
So your attorney's gonna have to file a motion in front of the trial judge to get you a new bond.
Okay, because the only thing I was saying is, because I know they order commissary back in the cells. I came in with $128. I was wondering if I could maybe transfer that to an account, maybe to my commissary account, maybe. So
You'll
that
have
way
to
I can
talk-
order food.
You'll have to talk to the attorney about that. I don't have any idea how the jail operations works with that.
Okay.
All right, good luck, sir.
Okay.
Please tell me your name.
Junior George.
21MM4084, you're here charged with retail petty theft. I'm going to appoint the Public Defender's Office to represent you. I reviewed the probable cause affidavit. There is probable cause in this case. Your bond will be $500. You're not allowed to return to the Walmart located at 11250 East Colonial Drive. Do you understand that?
Yes.
You also can't have any contact with the witness in this case.
Yes, ma'am.
At this time, I'm revoking your ROR in 21 CF 3432 for aggravated battery, 2 counts.
Your Honor, he's been appointed RCC on that case. I would have you just set a different monetary bond as opposed to revoke and set it none, as we aren't Mr. Jorge's attorney in that case.
I'm not inclined to do that, Counselor. You'll have to give me a reason.
I guess I don't have any.
I show that he's out on bond in a violent felony case and he's arrested for petty theft. So again, my question would be, what reasonable conditions can this court place on your client that protect the citizens of Orange County?
I just felt that because it was regional counsel's case that I didn't want to act on or speak for him in that case. That was my reasoning initially, to argue a higher monetary bond if he were so inclined.
No, sir, your attorney's going to have to file a motion in front of the trial judge. Good luck. Good afternoon, sir. Please tell me your name.
Johnny Thompson.
You're here in 21 MM 4085, charged with trespass on property after warning. I'm going to appoint the Public Defender's Office to represent you. I reviewed the probable cause affidavit in this case, and there is probable cause.
Your Honor, may I approach?
Yes. All right, Mr. Thompson, what we're going to do is, I'm going to order that you be screened for mental health pretrial release. If you qualify for that, you'll be released into that program. And I'm not going to revoke your out on bond cases, but you're not going to be able to return to the Highway Food Mart. Do you know where that is?
No.
It's located at 700 West Church Street. So you can't go back to that Highway Food Mart, okay? Do you understand? You're nodding your head yes. Does that mean yes?
No.
Okay. All right, we're going to have you screened for that program. Good luck, sir.
And if he doesn't qualify, then you want him brought back for a bond? Or you want to go ahead and give it?
I'll set the bond at $250. Maybe you can leave a note for the public defender's office. If he doesn't qualify, try something else.
Yes, I will, Your Honor.
Thank you.
Thank you, Your Honor.
Yes, sir. Thank you, counselors, for your time and suggestions. Please tell me your name, sir.
Corey Edwards.
You're here in 21 CF 6915, charged with lewd or lascivious molestation of a child over 12 and solicitation of a child to engage in an act that constitutes sexual battery by a person in familial or custodial authority. A warrant was issued for your arrest, so another judge has already found probable cause. At this time, I'll appoint the public defender's office to represent you. Does the state wish to be heard on bond?
I'm sorry, Judge, what's this defendant's name, last name?
Edwards.
I have one moment, Your Honor.
Yes.
I believe the defendant is entitled to a bond. I don't think it's charged as the PBL on count.
I don't think it is.
I think it's charged as an F2, but let me just double check. That's why I wanted to. I think it's charged as the F2, Your Honor.
That's what I have.
We would just ask for a higher bond based on the allegations. We would also ask that the bonds be revoked in the 2 out on bond cases.
Your bond in this case will be $200,000 on count 1 and $100,000 on count 2. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yeah, we got
Get close to the microphone so I can hear you.
yes, ma'am. We got an altercation going on with my family, my wife and my kids. Well, me and my wife got an altercation going on with our kids. So this is my 15-year-old daughter that made a.
Right. What I'm telling you is you can't have any contact with the victim. Do you understand that?
Yes,
You also can't have any contact with her immediate family. I understand that's your immediate family. You can't have contact with them at this time. Do you understand?
Yes.
You're also not allowed to return to her residence for any reason. I'll order you must comply with any plan set in place by DCF. Are there any other conditions the state would request in this case?
No, Your Honor.
And at this time, I'm revoking your bonds in your 2 out on bond cases, so your attorney is going to have to file a motion in front of the trial judge. Do you understand?
Is this my public defender?
Yes. Yes, you can, absolutely.
Your Honor, on the out on bond cases, I think it's 20 CF 14965. There is an offer, I think, with his attorney downtown. I would have them resolve that as quickly as possible, and I don't think an information's been filed yet. I had a note as recently as June 9th that no information had been filed on the trespass case 21MM3324. I would have you consider that as In your consideration, the bonds and these current charges are so high that I believe that even revoking bond on the out-on-bond cases, the high bond now is enough to cement the fact that he needs to return to court when ordered. Don't miss any court dates, or that high bond would turn into jail time.
Counselor, you're gonna have to file a motion in front of the judges downtown. Good afternoon, Counselor.
How's it going, Your Honor?
Sorry for the wait.
That's all right.
If you'd like to put your appearance on record.
Yes, Dean Mosley, Your Honor, representing Denzel Turner.
All right, Mr. Turner. Is that who you are?
Yes, ma'am.
Thank you. This is 21 CF 6586. A warrant was issued for your arrest, charging you with murder. Another judge has already found probable cause. Counselor, did you wish to be heard on anything in this case?
Your Honor, I understand another judge has found probable cause, Your Honor. I would just ask, had the court made an independent review of this case to determine whether probable cause exists for the charge of first-degree murder?
I did. Counselor, I reviewed the affidavit prior to court.
Okay.
And I do agree with the other judge's finding of probable cause in this case.
Okay, Your Honor.
Are there any other issues that you'd like to be heard on?
No, Your Honor, I mean, if you find probable cause, I understand that because of the charge, you're not going to set bail.
Right. And your client would be entitled to a full Arthur hearing downtown in front of the trial judge. So if you want to reserve any arguments for that, I would understand, and that's probably in your client's best interest.
Yes, Your Honor.
I will just order you, Mr. Turner, even while you're in custody, to not have any contact with the victim's family members. Do you understand? You have to answer out loud.
Yes, ma'am.
All right, thank you. Thank you, Counselor.
Thanks, Your Honor.
Have a nice day. Please tell me your name. 21 CF 7036. You're here charged with robbery with a firearm. I'm going to appoint the Public Defender's Office to represent you. Mr. Brands, did you wish to be heard?
I'm sorry, what's the defendant's name, Your Honor?
Workman?
I was just conferring with our client, Your Honor.
All right, I just want to be sure if you had any argument to make.
No, Your Honor, not at this time.
All right, I do find there's probable cause in this case. Ms. Kennedy Swanson, what level felony is robbery with a firearm?
Punishable life felony, Your Honor.
That's what I thought. All right, at this time, you'll have no bond on this charge.
Wait, isn't it a first-degree felony?
With the firearm enhancement, it makes it a punishable life felony.
Right.
Oh, I saw it as a 10-20 life. Doesn't he have to be charged 3 times with it?
No.
Oh.
But even while you're in custody, I'll order that you're not allowed to have any contact with the victim or any witness in this case. Do you understand? I need you to answer out loud.
Can I get a bond on this?
I'm sorry?
Can I get a bond on this?
No, you don't get a bond at this time. This is charged as a punishable by life offense, so your attorney is going to have to file a bond motion in front of the trial judge to get a bond.
They didn't find a firearm, though. It wasn't no firearm. They just charged me with robbery. It wasn't no firearm.
Listen,
It wasn't.
the only thing we're doing here today, this is a probable cause determination, and then I set bond. But if you think you have some defenses to this, you want to talk to your attorney about those, and they can raise it at a later hearing in front of the trial judge. Wait, we're not done. Hold on. I need to make sure you understand what I said. Even while in custody, you can't have contact with the victim or any witness in this case. Do you understand that? And at this time, I'm revoking your out on bond case. So good luck, sir. Please tell me your name. 21 MM 239. You're here charged with trespassing. I'm going to there is probable cause in this case. Was there an offer?
Yes, there was, Your Honor, from the state. However, I have some comp concerns for our clients. I wouldn't be inclined to accept the state's offer at this time. Because of those concerns, especially in the out on bond case, I would have you take no action on the out on bond case and just a very low reasonable bond for the current charge of trespass. The nonviolent offense, and coupled with the competency concerns, I believe that it's better dealt with downtown and valuations and determining competency to stand trial.
I'm going to appoint the Public Defender's Office to represent you. Your bond is $500 in this case, and you're not allowed to return to First Baptist Church of Apopka.
I hope I die and my babies die too. That's what's gonna happen.
All right? She's also not allowed to have contact with any witness in the case. She's not allowed to possess a weapon of any kind, firearm or ammunition, and at this time, I am revoking her out on bond case, 20 CF 14659.
May I waive the remainder of her appearance?
Yes, thank you. Please tell me your name.
Sheldon Wallen.
All right, 21MM4062. You're here charged with retail petty theft. There is probable cause in this case. Is there an offer?
No, Your Honor.
All right, I'll appoint the Public Defender's Office to represent you. Your bond is $500. Hold on a minute. How does that even happen?
Your Honor, could
My
I,
pen just fell apart in my hand.
Your Honor, could I confer with state real quick?
Yes. Like, it just.
Yes, sir.
It's not a thing. Let me see if this works. That's all right. I don't know who touched it.
Your Honor, the state has no objection to no action on the out on bond and leaving the bond set as to this petty theft.
All right, there is probable cause. You're not allowed to return to the Circle K at 1650 East Silver Star Road. Do you understand?
Yes, ma'am.
You're not allowed to have contact with any witness in the case. I'll stay your bond at $500. And why would I not revoke the bond in the carrying a concealed firearm case?
Your Honor, that case has a court date, June 28th, a trial date. It looks like there's been an amended offer of a probation and a withhold that has been conveyed just at the end of last week. I don't know if the defendant knows about it. I don't know if his attorney has spoken to him. I think based on the offer and the trial date, which I'm assuming is going to be a plea date, in this case, I did not allow to go to PTD. The out on bond case, I did not allow to go to PTD. So based on all that information, Your Honor,
And I,
objection to leave the order.
thank you.
Yes,
I
Counselor,
spoke-
your client has 4 prior failures to appear.
I spoke with Mr. Wallen in the back about this, and he's guaranteed he's going to speak with his attorney at our office, and he will guarantee his appearance at that June 28th court date for his out on bond case, as well as any future court dates that are required.
And I can give the offer, Your Honor, and I would have no objection if we could pull him out today. The offer in the felony is a withhold credit for time served, withhold credit for time served, followed by 12 months of probation, 50 community service hours to forfeit the firearm and court costs. I know he can't resolve it today.
No.
To put it on the record, that was the offer.
I'm still trying to understand how that helps this court with reasonable conditions I can impose on your client with which he'll comply, given his history and the fact that he's out on bond for a felony and he's committing a new law violation. What are the conditions?
Understand, I mean, I've spoken with him personally, and he's been working with our office. Usually, a lot of clients just don't call back or write back or contact us at all, and they end up missing court dates. If he's working with our office, the bond in the current charge, as well as the bond that he has on the out-on-bond case, it seems like it is working in recalling him for any future court dates. The idea of bail is to guarantee the client returns for court.
All right, good luck, sir.
Thank you. I appreciate you.
Yes, sir.
Thank you, Your Honor.
I'm taking no action on that. Please tell me your name. What's your name?
Jones, ma'am.
I'm sorry, did you say Ellis?
Yes, ma'am.
All right, thank you. This is 18 MM 7364. A warrant was issued for your arrest for violating probation in that the probationer did not comply with instructions given to him by the court on November 17th, 2020, when he failed to report to the Orange County Probation Unit by phone within 48 hours of release. Another judge issued this warrant. There is no bond authorized on that, and I'll appoint the Public Defender's Office to represent you. Good luck, sir.
I'm sorry, do the PD want to do a denial?
Mr. Brandt, do you want to enter a denial in this, and we'll set it for...
On behalf of our client, we'll enter a denial, Your Honor, yes.
DLP status hearing would be July 9th at 9 a.m. courtroom 7C.
All right, good luck, sir. Please tell me your name.
Jacques Enso.
In 2020 CF 14812, a warrant was issued for your arrest for violation of a condition of pretrial release. There's no bond authorized on that warrant, and I'll appoint the Public Defender's Office to represent you.
Your
In
Honor,
21, yes?
I believe we were previously withdrawn on that case.
I can't hear you.
I believe we were previously withdrawn in that case. I don't know if reappointing us, I believe he has a private attorney on his out-on-bond case. I'm assuming we withdrew because he wanted a private attorney on his current.
Okay, all right, then I won't appoint the Public Defender's Office, thank you. In 21 MM 4077, you're here charged with attempted resisting an officer without violence? Attempt?
We're gonna, no objection to RO right now.
I mean, I can do that, but he's being held at no bond on other things, so then he won't be entitled to credit on this. But I'll do that.
It's fine, Jeremy, if you want, I can't imagine us going forward on attempted,
I'm sorry?
I can't imagine we will go forward on attempted.
An attempt? All right.
Yes, so that's,
As a friend of the court, though, Your Honor, if you can get credit time served for the no bond status, then
that's fine. I don't mind leaving the bond as is, just because he's gonna be held at no bond.
he can use the credit later.
I mean, the judge could give him the credit, he's just not entitled to it, so that's all.
I don't think we want to play those games with the downtown judges. I think we should just hold it with some, with the bond. So it's not a question of discretion later on.
I saw on the arrest affidavit, I think it was like $250.
Wait, I can't hear you.
I saw on the arrest affidavit, the attempting was $250.
Right.
Notice no lower to $100.
All right, I'll leave it. And then at this time, I'm revoking your out on bond case, 20 MM 4354.
Again, he does have a private attorney on that out.
Right, you'll want to contact your attorney, sir. You understand that? So you're being held at no bond right now, so you need to talk to your attorney so that they can file a bond motion if you want that. But you don't have a bond.
I didn't commit no crime to be here.
I can't hear you. Get closer to the microphone.
I didn't commit no crime to be here.
So there's a warrant that was issued for your arrest for violating a condition of pretrial release. That was issued by another judge, so you're gonna have to go in front of that judge to address that warrant. But there's no bond authorized on it, so that's why I'm saying you need to talk to your attorney because you can't bond out. All right, good luck. Please tell me your name.
Hey, how you doing? My name is Joshua Ponte.
21 CF 7032. You're here charged with burglary of an occupied dwelling and criminal mischief, damage greater than $1,000. I'm going to appoint the Public Defender's Office to represent you. There is probable cause in this case. Hold on. Fix that.
He does otherwise qualify for PTR, Your Honor.
What says the state?
No objection.
I'm not inclined to do that. This is a very violent case.
He has a very slim criminal history as well, and for your consideration.
I'll place you on pretrial release and also require that you post a monetary bond. Your bond on count 1 will be $4,000. Your bond on count 2 will be $100. You're not allowed to have any contact with the victim or any witness in this case. Do you understand what no contact means?
Yes, ma'am.
You're not allowed to return to her residence for any reason at all. Do you understand that?
Yes, ma'am.
You're not allowed to possess a weapon of any kind, firearm, or ammunition. You're not allowed to possess or consume alcoholic beverages or controlled substances without a valid prescription, and you'll be subject to random drug and alcohol screens while on pretrial release. Do you understand?
Yes.
Are there any other conditions the state would request?
No, Your Honor.
Good luck, sir.
Thank you.
Yes, sir. Sir, please tell me your name.
Jerome Bowen.
A capias was issued for your arrest in 21 CT 3962 for failing to appear for arraignment on a charge of driving while license suspended with knowledge. The bond authorized on that is $250, and I'll appoint the Public Defender's Office to represent you. In 21 CF 7034, you're here charged with possession of MDMA.
Your Honor.
Yes.
I do have some PC concerns with the initial trespass. The probable cause for the initial trespass didn't pan out, so we would
Wait,
request.
what trespass?
This is where he was, I think this is the case where the neighbor called saying that they were in a car.
He's not charged with trespass.
No, I understand. The probable cause initially for the walk-up was the police officer thought they were trespassed.
And we wasn't, we had permission to be there.
Therefore, I think the initial walk-up might have some probable cause concerns. I would just request ROR on the possession. And
I
also,
think that's more of a motion to suppress, not a IAC issue.
Right.
And the defendant is out on bond.
just threw
Right.
up red flags for me, Your Honor, when I
Wait, get closer to the microphone.
It threw up red flags for me because later in the affidavit, it stated that the owner of the property had allowed them to be there. So there was a phone call that someone, I guess a neighbor or someone nearby said, oh, they're not supposed to be there. A police officer shows up when they were legally allowed to be there. So I had probable cause concerns about the initial walk-up, but
So in the probable cause affidavit, it says they were not trespassed from the property because the law enforcement officer spoke with the owner of the residence and who advised that Reed and Bowen were allowed to be on the property. So as to trespass, you might be correct that there's a probable cause issue, but as to the possession of MDMA, there is probable cause.
I'm saying this, I don't want to repeat myself, Your Honor, but it.
I understand, but I think,
The walk-up stemmed from a non-PC.
so I think what you're arguing is that you need to suppress, you want to suppress that evidence, but we're not doing that here
I
today.
understand, but I still was requesting ROR on the possession charge because of those circumstances.
Because I would have never got.
All right, sir, your bond is $1,000. You're not allowed to possess or consume any controlled substance without a valid prescription. Do you understand?
Yes.
You're also not allowed to have any contact with the co-defendant in this case or any known drug dealers. Do you understand that?
I don't understand that. The co-defendant meaning my wife?
I'm sorry, what?
The co-defendant meaning my wife, Ms. Reed?
I don't know who's
Morgan Reed is my
Morgan
fiance.
Reed, Your Honor.
Reed.
That's my fiance.
No objection.
Is that who was with you when you had the MDMA?
Well, I didn't have the MDMA. We were in a car on a place where we were supposed to be. They came back there and told us that we were
It's okay. You don't have to say anymore. Once Reed was out of the vehicle, I ordered Bowen to exit the vehicle.
No objection to letting them have contact, Your Honor.
Your Honor, I wonder if we could bring Ms. Reed and if you wanted to question both of them about contact, or if you had already made a decision about contact.
No, since the state's not objecting, I'll allow you to have contact with her. And at this time, I'm revoking your bond in 21 CF 5642. Good luck, sir. You're out on bond for a felony and you're arrested for a new felony. That's why I'm revoking that bond. So your attorney can file a bond motion in front of the trial judge. Please tell me your name.
Angel Burgos.
21 CF 7021. You're here charged with fleeing or attempting to elude law enforcement with lights and sirens activated. There is probable cause, and I'll appoint the Public Defender's Office to represent you. Does the state wish to be heard on bond?
No, Your Honor.
Your bond is $15,000. Good luck, sir.
Just a moment, Your Honor. Your Honor, that might be an unattainable amount for our client if you would consider lowering that bond amount so that he could at least bond out, have a chance to bond out.
Counsel, I need you to tell me what in the statute is a reason that I should lower it.
Well, the bond does have to be attainable to a client. I think it's Camera v. State.
I don't think that's in the statute, Counselor.
I know, but there's case law that suggests that monetary bond has to be attainable to the client. If he's a millionaire, he could afford a $15,000 bond.
If he's a millionaire, he can afford $1 million bond.
Absolutely. That goes to the excessiveness of the bond. The unattainability goes to the fundamental fairness of the due process clause of our clients, that if they're poor and you set a high bond, they couldn't get out anyway. Everyone's entitled to bond, but if you set it at a higher amount, they're stuck in jail. You might as well just give them pretrial detention, which is fundamentally unfair.
Counselor,
Your client can afford that or not afford that. Your client has put no testimony on.
right, there's no evidence before this court that your client can't afford that bond. So if you want to have a bond hearing and present evidence, we can do that. We're not going to do it right now. We'll bring him back at the end of the docket.
Did he file a affidavit of insolvency?
I don't know, I don't have it.
Madam Clerk, does he qualify for the public defender?
He didn't complete one. So no, we'll not be having a hearing on that today. He can file a motion in front of the trial judge. Please tell me your name.
Elena Falzone, Your Honor.
21 CF 7023. You're here charged with aggravated assault with a deadly weapon. There is probable cause in this case, and I'm going to appoint the Public Defender's Office to represent you. Your bond is $3,500. You can't have any contact with the victim in this case. Do you understand
Yes.
what no contact means?
Yes, Your Honor. The victim is not pressing charges at this time.
It doesn't matter what they want. What I'm saying is you can't have any contact with them. Do you understand that?
Yes.
You also can't have contact with any of the witnesses in this case. You're not allowed to possess a weapon of any kind, firearm, or ammunition.
Yes, Your Honor.
Were you living at 3714 Aristotle Avenue?
Yes, Your Honor.
All right, you can't now. I'm going to order you must maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim or the witnesses. Do you understand?
They weren't living there at the time, Your Honor. I was the only one living there. I tried to kick them out, and they actually threatened to shoot up my house.
All right, so if they're not living there, you can. But
Okay.
this court does not have jurisdiction to order them to leave. So if you go there and they're there, you can't stay. Do you understand?
Okay. Yes, Your Honor.
You can't possess or consume any controlled substance without a valid prescription. Good luck, ma'am.
Wait, can I?
You can ask a question.
How long do I have, Your Honor?
How long what?
Do I have in here, Your Honor?
I don't understand.
In here.
You have a bond, so you have to post the bond to get out.
That's it?
Right,
There's no amount of time set, it's just the bond?
right.
Okay.
Good luck. Please tell me your name. What's your name? In 21 CF 7018, you're here charged with burglary of an unoccupied conveyance. There is probable cause for that charge, and I'll appoint the Public Defender's Office to represent you. Your bond is $3,500. You're not allowed to have any contact with any witness or victim in this case. Do you understand what that means? You're also not allowed to return to the area of North Knowles Avenue and Lincoln Avenue. Do you live near there? I'm sorry? Knowles.
Okay.
Do you live near there?
Kinda.
All right, don't go back to whatever that neighborhood is. And you're not allowed to possess a weapon of any kind, firearm, or ammunition. In 21 CF 7017, you're here charged with burglary of an unoccupied conveyance and resisting an officer without violence. There is probable cause, and I'll appoint the Public Defender's Office to represent you. Again, you're not allowed to have contact with any victim or witness. You're not allowed to possess a weapon of any kind, firearm, or ammunition. And at this time, I'm revoking your out on bond case 20 CF 12848.
Is that, Your Honor, is that the same bond amount in 7017, 3,500 and 100 on resisting?
Yes.
And the only argument it's not an argument, but it's more of a,
Wait, just get closer to the microphone.
more of a good faith comment. He is seeking inpatient treatment to resolve some of these issues, so I would have you consider that in your out on bond decision.
Thank you. Please tell me your name. In 21 CT 4320, you're here charged with driving under the influence. There is probable cause, and I'll appoint the Public Defender's Office. Your bond will be $500. You're not allowed to possess or consume any alcoholic beverage, and you can't possess or consume any controlled substance without a valid prescription. Do you understand? In 21 CF 7039, you're here charged with resisting an officer with violence. There is probable cause, and I'll appoint the Public Defender's Office to represent you.
No objection to treating that as a subsidiary and a $100 bond, Your Honor.
Thank you, but I won't do that. Your bond is $1,000. Again, you're not allowed to possess or consume any alcoholic beverages, and you can't possess or consume any controlled substance without a valid prescription. Do you work at the Circle K? All right, you can't go back to that Circle K. Do you understand?
My car is still there from what the cop told me, so how can I get my car back?
No objection to one-time return with law enforcement.
All right, I'll allow a one-time return with law enforcement to get your car. Yes, ma'am. Good luck. Please tell me your name.
Christopher King.
21 CF 7042. You're here charged with possession of MDMA. I'll appoint the Public Defender's Office to represent you. There is probable cause in this case. Your bond is $1,000. You can't,
He does otherwise qualify for PTR, and as it is a nonviolent possession charge and drug abuse related, the PTR services or pretrial services can oversee him to hopefully keep him from continuing to abuse drugs. Then I feel that should be a sufficient
No objection.
bond condition.
all right, I'll place you on pretrial release with special conditions. You're not allowed to possess or consume any controlled substance without a valid prescription. Do you understand?
Yes, ma'am.
You'll be subject to random drug screens. You also can't have contact with any known drug dealers.
So what does this mean?
It means you're going to be placed on pretrial release and released.
Today?
I think so, at some point today. It'll take some time to process you out.
Because I have to go to work.
I can't hear you.
I have to go to work. I had to work today. But I have to work at least tomorrow.
Yeah, I think it takes them a couple hours to get you out.
Yes, ma'am.
All right, good luck, sir. Please tell me your name.
Michael Jermaine McIntosh.
21 CF 7044. You're here charged with resisting an officer without violence and possession of cocaine. There is probable cause, and I'll appoint the public defender's office to represent you. Your bond is $100 on count 1 and $1,000 on count 2. You're not allowed to possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand?
Yes, ma'am.
At this time, I'm revoking your out on bond case 21 CF 5362. Good luck, sir. Please tell me your name.
James Moulton.
A capias was issued for your arrest in 21 CF 2805 for failing to appear for arraignment on a charge of possession of cocaine. There's no bond authorized on this capias, and I'll appoint the public defender's office to represent you. Good luck, sir.
I got a question.
Yes. Do you still have a question, sir?
He's just worried about the amount of time to get in front of that judge to have it re-argued, Your Honor. He's transient, he's got a family that's also transient.
That'll be up to your attorney. The public defender's office. So make a call as soon as you can. Good luck, sir. Please tell me your name.
Alexis Quintero. Alexis Quintero Gonzalez.
21 CF 7040. You're here charged with possession of synthetic cannabinoids. There is probable cause, and I'll appoint the public defender's office to represent you. Your bond is $1,500. You can't have any contact with the co-defendant, with any known drug dealers. You can't possess or consume any controlled substance without a valid prescription. Do you understand? In 20 CF 3288.
Your Honor, if I can be heard again, my same argument for drug addiction issues, especially the out on bond case, fentanyl is extremely addictive and harmful. And that if he's withdrawing on those drugs, then his body's seeking out this K2, which is a synthetic drug. I've done some research. K2 is addictive. Fentanyl is very addictive. I would have you consider that in your determination what to do with the out on bond case. It's also nonviolent offenses. He isn't hurting anybody other than himself.
What are the reasonable conditions this court can place on your client with which he'll comply, given he's out on bond for a felony and is arrested for a new felony?
Again, a higher monetary bond could also shock him into avoiding these drugs in the future. Again, I can't speak for the physiological effects of him personally. If he's going through withdrawal symptoms or not, I don't know any of that. But
Counselor, a few cases ago, you just told this court that high monetary bond is tantamount to no bond.
that's if he cannot afford it.
I'm sorry?
That's if a client cannot afford the bond set. If it's a higher monetary bond on a bond that's already been set, that goes to affordability. That doesn't go to the effects of the bond to produce the client when the court date arrives.
Did you read the cover sheet on this defendant?
Yes, Your Honor.
What says the state?
Ooh, that's the court's discretion.
Is that an Osceola case? All right, I'm going to take no action on that. Good luck, sir. Please tell me your name.
Robert Ray, ma'am, Judge.
21 CT 576, 577, and 578. You're here charged with reckless driving with damage to persons or property, no valid driver's license, and leaving the scene of an accident. There is probable cause, and I'll appoint the Public Defender's Office to represent you. Your bond will be $500 and then $100 and $100. You cannot drive without a valid Florida driver's license. Do you understand?
Yes, ma'am.
You're not allowed to have contact with any victim or witness in these cases. As to 21 CF 7043, you're charged with fleeing or attempting to elude a law enforcement officer with lights and sirens activated and resisting an officer without violence. There is also probable cause in this case. I'll appoint the Public Defender's Office to represent you. Your bond is $15,000. You're not allowed to have any contact with, and then $100 on the resisting. You're not allowed to have any contact with any co-defendant or witness in this case. Do you understand?
Yes, ma'am.
All right, good luck, sir.
Javar Reed, he refused court.
Twenty-one MM4100. I find his refusal a willing waiver of his appearance today. I'll appoint the Public Defender's Office to represent him. There is probable cause. I'll stay his bond at $500. He's not allowed to return to,
Denny's.
it's what?
I think it's a
Denny's, yes, you're right. Or have contact with any victim or witness in the case. Please tell me your name.
Morgan Reed.
I'm sorry, I couldn't hear you. One more time.
Morgan Reed.
21 CF 7035. You're here charged with possession of MDMA.
Your Honor.
Yes, sir?
If this is the same, this is the other co-defendant from that case about the, my issues with the walk-up. Looking at her criminal history as well as her qualifications for PTR, I would have you either do an ROR on the possession or at least have her qualify, because she's qualified for PTR, issue PTR and no monetary bond.
No objection to PTR.
All right, there is probable cause in this case. I'll appoint the Public Defender's Office to represent you. I'll place you on pretrial release with special conditions. You're not allowed to have any contact with any known drug dealers. You're not allowed to possess or consume any controlled substance without a valid prescription, and you'll be subject to random drug screens. Do you understand? Good luck. Please tell me your name.
Russell T.
A warrant was issued for your arrest in 21 CF 7048, charging you with robbery with a firearm. Another judge has already found probable cause in this case. I'll appoint the Public Defender's Office to represent you. There is no bond authorized on this warrant. However, I will order that even while in custody, you're not allowed to have any contact with any co-defendant or victim in this case. Do you understand that?
Yes, ma'am.
Yes, sir.
Just a moment, Your Honor.
Yes, yes.
Your Honor, if Mr. Teague gets a full evidentiary hearing and Arthur hearing downtown with his attorney as well.
Yes. Good luck, sir.
Thank you.
Please tell me your name.
Sonny Thornton.
21 CF 7049. You're here because a warrant was issued for your arrest, charging you with robbery with a firearm. Another judge has already found probable cause. I'll appoint the Public Defender's Office to represent you. There's no bond at this time, but even while in custody, you're not allowed to have any contact with any co-defendant or victim in this case. Do you understand that? And Dexter?
Yes, ma'am.
Thank you. This is one of those co-defendant cases that we were talking about last week. So if you can make a note for them not to be together.
Mr. Thornton also qualifies for a full evidentiary Arthur hearing downtown with his attorney to reconsider bond.
Yes, sir. Good luck, sir. What was the first name? Teague. It's Teague and Thornton. Please tell me your name.
Joshua Vargas.
You're here in 21 CF 7050, charged with aggravated battery with a firearm, possession of cocaine, and possession of drug paraphernalia. There is probable cause in this case.
Your Honor, if I can be heard on the possession of drug paraphernalia,
Yes.
I don't believe there were any facts to suggest to hold that charge of probable cause.
Wait. Get close to the microphone.
On the charge of possession of drug paraphernalia, I don't see any facts that suggest that there was enough probable cause to charge Mr. Vargas with that. We would have you ROR him on that charge.
The bag,
The bag would be
which the cocaine was found in?
that's the paraphernalia. Anything used to transport it in.
Right. That's the paraphernalia I saw probable cause for.
Paraphernalia was used to intake
No.
illegal substances. It can,
No,
it can carry illegal substances?
can carry it, yep.
Yes.
However, the state is going to have no objection to ROR to that count anyways. There's PC.
There is, and he won't get credit,
No, he'll get credit for the other counts. So yes,
but not on this one.
it won't matter for the counts purposes. It's only when it's a different case number.
All right, I'll ROR him on the third count. But you'll be held at no bond on count 1 and $1,000 on count 2. You're not allowed to have any contact with the victim or any witness in the case. You're not allowed to possess a weapon of any kind, firearm, or ammunition. You're not allowed to return to the Burger King located at 7623 East Colonial Drive. You're not allowed to possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Any other conditions the state would request?
No, Your Honor.
Mr. Vargas also is entitled to the full evidentiary at the hearing downtown with his attorney.
Yes, he is. Good luck, sir. Please tell me your name.
John Davis White.
21 CF 7031. You're here charged with possession of MDMA with intent to sell. I'm going to appoint the public defender's office to represent you.
Ma'am?
Yes.
Yes.
Did you have a question?
I thought you said public defender.
I can't hear you.
I thought you said public defender.
Yes, he's the representative from the public defender's office. I'm going to appoint the public defender's office at this time to represent you.
Okay.
There is probable cause. Your bond is $15,000. You're not allowed to possess or consume any controlled substance without a valid prescription. You're not allowed to have contact with any known drug dealers. You're also not allowed to return to the 7-Eleven at 1 North Rosalind Avenue. Do you understand that? You have to answer
Yes.
with words. Thank you. All right, good luck, sir.
Your Honor, on the affordability factor, again, he was very cooperative with police. He has 2 children. He's unemployed and homeless, and has been unemployed for an indefinite amount of time. If you would consider lowering that monetary bond so that the client can afford to bond out.
All right, sir, that's not a factor in the statute. I understand that you keep wanting to argue it, but there's been no evidence presented to this court of any of your arguments.
I believe there's case law. I printed it out if you would like to see it.
You're still going to have to present evidence to support the argument in order for me to make a finding, and I need the case law.
Give me a moment, Your Honor. I have it right here. Well, I don't have it. I thought I did. But I'll be better prepared for those arguments. However, the case law does suggest that you must consider all the monetary factors, income factors of a client in determining bond. It's not in the statute, but it is in case law, Camera v. State, I believe. I think it's a 5th DCA case.
Counsel, you'd still have to present evidence. There's been no evidence presented to the court.
I understand, Your Honor, but based on the PTR sheet, he's unemployed, and with the arrest affidavit, you also saw not only unemployment, but also homelessness.
How would the affidavit of indigency come in for evidentiary purposes for this particular issue?
Did he sign an affidavit of insolvency?
How would it come in as far as this issue? I agree that it comes in for affidavit for indigency purposes, That's not what you're asking for right now. So how does it come into this hearing now related to bond?
If he can't afford it, he can't bond out.
I
And
agree.
it's a due process issue. If he can't afford it and can't bond out, then due to his income, he's being treated differently than clients with higher income.
No, Counselor, there's no evidence before this court of the assertions that you're making. So what you're saying is this court is treating people differently, but there's no evidence of that. In fact, this court works very hard to treat people consistently based on the charges, the facts, and the criminal history. This court also works very hard to follow what's in the statute. There's a Florida statute regulating bond, and that's what binds this court. So if you want to make arguments that are not supported by evidence, this court is, I don't have a choice. I can't follow those arguments, Counselor. There has to be evidence.
I understand, Your Honor. I'm not accusing the court of treating anybody. I'm just trying to make sure that, at least from our office's perspective, we didn't argue the best we could for indigent clients that can't afford a high bond.
This isn't a high bond, Counselor. This is consistent with,
I can't afford that. I can't afford that bond, Your Honor.
I believe you, sir.
I can't afford it. That's why I was doing what I was doing.
Here's the thing. I have to look at the probable cause affidavit, which is what I have, and I read it. It sounds to me like you might be in a really tough spot. I believe that. However, the only determination I can make today is whether there's probable cause to believe you committed this crime. And unfortunately, there is. So, based on that crime and your criminal history, I'm leaving the bond at $15,000. But your attorney can file a motion in front of the trial judge to reduce that. They can also present evidence of your income, your ties to the community. There's all kinds of factors that are in that statute, and they can present that evidence, and the trial judge can change my order anytime. You understand?
Yes.
All right, good luck, sir. Please tell me your name. All right, in 2006, CF 13874, a capias was issued for your arrest.
Can I have a moment to speak with Mr. Williams, Your Honor?
Yeah, hold on, let me tell him about the capias.
Fine.
But yes,
Sorry, Your Honor.
it's okay, I just want to tell him why he's here. So the capias was issued for your arrest, saying that you failed to appear for a VOP, a violation of probation arraignment hearing. There's no bond authorized on this, and I'm going to appoint the public defender's office, so now you represent him and you can speak to him.
Thank you, Your Honor.
Yes, sir.
Your Honor, this is an interesting case. He's been up in Daytona at the Tomoka Correctional Institution, and he's a pro se litigant, so I did speak to him as a friend of the court. He did file a motion for final disposition of detainer while in custody in Daytona, and then there was a transfer order, or transport order from Daytona to Orange County Jail. And then he has a hearing set on that motion for final disposition of detainer on June 25th, 2021. Mr. Mr. Williams is wondering if he can deal with the issues that are keeping him here now, today, or does he have to wait until June 25th to go in front of Judge Barber, I believe? Elaine Barber?
Judge who?
Elaine Barber.
Oh, Judge Barber.
She signed the transport order as well as the order setting a status hearing. I believe the original charge from 2006 had 30 months probation on it, and he was wondering if the state has an offer to resolve that today so that he can go back to Daytona and start working in a, the reason why he wants to be in this work service program, and this is keeping him from participating in that. So I would have you, I have the,
The issue is this court is not going to have jurisdiction to resolve the case. It's not
Right.
that the state won't make the offer, it's that we can't resolve it.
So this court doesn't have jurisdiction to resolve this case because it's a circuit court case. Additionally, because it's a capias that was signed by another judge, I can't change the bond because it's the type of arrest instrument. But
What I will do.
But I can't accept a plea on this case. However, I did just appoint the public defender's office to represent you. If you call that number, perhaps you can get the public defender's office to move that hearing sooner than June 25th. Ask them if they can talk to the judge and get that hearing moved sooner.
I will send an email to the ASA that has this case.
Okay, perfect. Thank you.
I appreciate that. Thank
Yeah, because maybe we can move it, we'll try to move it as fast as we can. I just don't know if Judge Barber has time on her calendar. Yes, sir. Good luck. Please tell me your name.
Gregory Walters.
You're here in 21 CF 7014, charged with attempted burglary of an occupied dwelling, unlawful discharge of a firearm, and criminal mischief with damage greater than $1,000. There is probable cause here, and I'll appoint the public defender's office to represent you. I'll stay the bonds. $2,500 on count 1, $500 on count 2, and $1,000 on count 3. You're not allowed to have any contact with the victim or any witness in this case. Do you understand?
Yes, ma'am.
You're not allowed to possess a weapon of any kind, firearm, or ammunition. You're not allowed to return to 3586 Aristotle Avenue. Do you live there?
Yes.
All right. I'll order that you must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings.
Your Honor, on his out on bond case, if you're considering that at this time. He's participating in opioid court, I believe.
In what?
Opioid court with Judge Lattimore.
No, that's a firearm case as well, Counselor. These are both extremely dangerous, so at this time, I'm going to revoke that bond. You can take it up with Judge Lattimore.
He probably was in drug court though, because I see a contract signing date. With then Judge Whitehead, so now Judge.
Okay, he'll have to take it up with Judge Lattimore and Judge Whitehead.
Revoking?
Yes. Good luck, sir. Please tell me your name.
Sharmisha Cooks.
In 2017 CF 6898, you have a violation of probation. There's no bond, and I'll appoint the public defender's office to represent you. Yeah, that's it. All right. Good luck.
We were appointed, yes? On that.
I did, yes.
Thank you.
Please tell me your name.
Kenneth Reeves.
In 2017 CF 16672, a warrant was issued for violating your probation by failing to make a full and truthful report to the probation officer, changing your residence without first procuring the permission of the probation officer, and by committing the new law violation of simple battery in Houston County, Georgia. There's no bond authorized on this warrant, and I'll appoint the public defender's office to represent you. Good luck, sir.
Your Honor, Watts, he refused court.
All right, 21 CF 6997, I'll find his refusal a willing waiver of his appearance today. There is probable cause in this case. His bond will be $5,000 on count 1, $500 on count 2, no bond on count 3, $500 on count 4. And can the state advise count 5 is a PBL? I don't think it is.
No, Your Honor.
And his bond on count 5 will be $50,000. He's not allowed to have any contact with the victim or any witness in this case. He's not allowed to possess a weapon of any kind, firearm or ammunition. He's not allowed to return to the scene for any reason. And at this time, I'm revoking his 2 out on bond cases.
He is entitled to an evidentiary Arthur hearing as well on the kidnapping charge, Your Honor.
Yes, he is.
Downtown.
I'm sorry, Your Honor, what was the bond on count 5?
$50,000.
Thank you, Your Honor.
Please tell me your name. I can't hear you. Get closer to the microphone.
Rodriguez.
Did you say Joel Rodriguez? Okay, I just want to make sure I'm talking to the right person.
I'm sorry, Your Honor. On the previous minute, did not have a on-duty DOP affidavit as well?
Hold on one moment, Mr. Rodriguez. Yes, there is. Let's go back to Mr. Watt's case. Remember, he didn't want to come to court today, so I find that a willing waiver of his appearance. There is also an affidavit for a violation of probation. A warrant was issued for his arrest. There is no bond authorized on that, and I'll appoint the Public Defender's Office to represent him in that as well. It's 20 MM 8433. Thank you, I missed it. All right, Mr. Rodriguez, let's look at your cases again. You have 2021 1061 charged with petty theft and driving while license suspended or revoked, third or subsequent offense. There is probable cause for both of these charges. I'll appoint the Public Defender's Office to represent you. I'll stay your bond at $250 on the petty theft and $2,500 on the driving while license suspended charge. You cannot drive without a valid Florida license. Do you understand? You also cannot return to the Shoe Carnival located at 451 East Altamont Drive. You can't have any contact with a victim or witness or co-defendant in this case. At this time, I'm revoking your out on bond case, 21 CF 5570. Good luck, sir. Any other business before court is adjourned for the day?
Yes, Your Honor.
Yes.
I had a message from an attorney in our office, case number 21MM003150. If I may approach.
Yes, please.
He had a 33-day motion granted on Friday, I believe, but he's still in custody.
We would have, state would need a whole moment for that one,
What?
on multiple levels.
Does anyone know why he's still in custody? Here, let me show you this. Sorry, I was hoping to get it further out. Does he have another case? That is not my signature, and that doesn't look like Judge Bain either. That looks like, well, I guess it was, oh. It was a different judge on Friday. We were both out.
Bigney and Brunson, wasn't it?
Oh, it's Bigney? Okay.
So I see he was ROR'd on 2021 MM 3150 on the 11th, and he still has an open case for 21 MM 3151.
So that's why.
Can you repeat that, please?
3151.
And then, Your Honor, I also had that case law I was speaking of. I found it, if you would like it for your reference.
Yes, thank you. And, yes, please, and you can have this one back. Thank you.
Are we still on the record, Your Honor?
Yes,
Can we go off the record, Your Honor?
yes.